Mediation, it's an alternative method for resolving disputes to the traditional litigation or arbitration. It's voluntary, it's confidential, it's facilitated by an independent third party called the mediator, and the mediator is trying to help parties who are in a dispute to see if they can find a mutually acceptable basis to settle. So as such, they can't settle on their own, and the mediator comes in and facilitates and tries to help them get to a settlement. It starts with the parties choosing a mediator, and then the parties and the mediator will sign a mediation agreement, and that'll govern the process and how it goes forward. The parties and the mediator will then agree what preparation is needed. Sometimes the mediator will need a briefing, what the case is about, or the parties might need more information from each other. Once they've had that preparation phase, they'll meet, typically for a single day, and the mediator on the day will spend time going between the rooms, the parties each having their own room, talking to them, seeing what progress can be made in narrowing the gaps and seeing if a settlement can be reached. And if it can, the settlement terms are then written down, and that's called a mediation settlement, and under the new act it's signed by the parties and the mediator, and it's an enforceable binding contract. Many advantages. I suppose the first is that it's private, unlike litigation, so you're not having to air your dispute in public, and that can be very important from a reputational perspective. Secondly, it's very client-centred, so the clients are deciding the outcome. The mediator, unlike a judge or an arbitrator, doesn't decide, so they're facilitating, they're not adjudicating. That's a very big difference. It's very flexible as to outcomes, so a party might decide they'd give a credit note, they'd provide free services, they could enter into a contract, they can give an apology, and all of these things can be part of a settlement in mediation in a way that they can't in court. It's very quick, it happens more quickly than litigation, so it saves time and saves huge cost, and if you have an ongoing business relationship, it can be very valuable in saving the relationship. The lawyer's answer to that is it depends on the case, but I've seen mediations. There was a case reported in the papers between the Dubliners, and they were in dispute with their recording company, and that case mediated over the course of between a Monday and Friday. The mediator was appointed and it settled, and that was because there was a time pressure, they were going on tour. So that's an example of it happening very quickly. Some cases it may take months. For example, in construction disputes, the parties might agree to have an exchange of expert reports, maybe an on-site inspection, so the preparation phase can be longer. But the normal experience would be that you would mediate within somewhere between 4 and 8 weeks from when you've appointed the mediator, and the time delay is often just finding a date that suits everybody. So versus litigation, which runs for a number of years, it's a very quick process. What does it cost? Okay, well, the mediator is obliged to set out their basis of charge before the mediation begins, and that's set out in the agreement. Some charge on an hourly basis, some charge on a fixed fee basis, and the fees are usually shared by the parties equally. So in my experience, in commercial mediations, I've seen parties incur costs of between 1,000 and 5,000 per party to pay the mediator's fees. And then if a party has lawyers involved in the case or experts, they may have additional fees. But in the scheme of a case that could cost hundreds of thousands if it was running in court, I think the cost is really, it's a much more manageable expense for clients. I think all sorts of disputes. I mean, mediation has been very successfully used in resolving workplace disputes, family disputes between husband and wife, family business disputes, which are not unlike family disputes, business disputes between shareholders, neighbour disputes where there can be boundary issues between farmers or in a residential area, and all sorts of commercial and contractual disputes. So really a very broad range. But the only exceptions might be in situations in particular if there's a government agency involved and they need a precedent judgment because the decision in the case has a relevance to other situations. But I think in many situations mediation has a value, and even in some states disputes it can work too. It works. It's obviously a confidential process, so you don't get a statistical analysis case by case, but there are quite a few published surveys both in the UK and the US which have varying success rates between 70% and 85%. So that means at least 7 out of every 10 cases going to mediation in those jurisdictions result in a settlement. In Ireland, there's much less published data, but there was a survey by the Irish Commercial Mediation Association a number of years ago which suggested a success rate of about 70%. And I think if you talk to colleagues, and my own personal experience of bringing clients to mediation, it's at least that sort of level, if not higher.